This program is brought to you by Emory University.
Welcome, everyone. We have a wonderful visiting scholar, Alice Margaria. Pretty good, that's why Italian, who is a PhD candidate at the Department of Law of the European University Institute in Florence, Italy. And she's actually going to talk to us today about her work on fatherhood and human rights. So welcome, and we're eager to hear what you have to say.
So good afternoon, everyone. Let me start with thanking Professor Marta Feynman for having invited me here as a visiting scholar. And more generally, I want to thank the Emory community that so far has been very welcoming. So I'm having a great time here. I'm taking this presentation as an opportunity to engage more directly with the Emory community. So I'm looking forward to the discussion after the presentation. So the presentation will try to address 3.5 why questions. Yeah, the last why question, it's just a question. There is no tentative answer yet. So the first question is, why fatherhood? The starting point is an historical and very practical one. So basically, in the last 50 years, we have witnessed a series of sociological and scientific developments that have concerned the structure, the form of families in Western societies, and I would say, to a lesser extent, also the functioning. So, for instance, one of the most tangible of these changes has been the increased participation of women in the workforce. As a result of a policy of gender neutrality that was strongly supported by the liberal feminist wave. So of course, this has to be seen as a great success of the gender revolution, but as Marta Feynman has argued, actually any revolutionary impact, any transformative rather than revolutionary impact of this change has been impeded by a tragedy. Namely, the fact that the neutering of mother has not been accompanied by a corresponding change in the institution of fatherhood. And so in response to this failure, to this lack of corollary change, my project aims to fill the existing gap by considering how a human rights-based approach can contribute to creating a new set of norms for fatherhood. So basically, the idea is to try to bring social and legal reality closer. So the second question that I'll address is, why the European Court of Human Rights? So I have two answers to this question. First of all, I think that it's interesting to look at the jurisprudence of the Strasbourg Court because of its long-standing, well-established engagement with the notion of family life for the purposes of Article 8. And most importantly, because the court has always tried to define what is a family through the lens of non-discrimination. So very, very often, in most cases, the finding of a violation of Article 8 of the European Convention, that is the right to respect for private and family life, is the result, is the consequence of the finding of a discriminatory practice. Fatherhood and motherhood are two concepts that are not directly discussed by the court. The court prefers to approach the question of who is a father or a mother by considering whether or not family life can be established in the case at stake. And the establishment of family life follows the employment of a test of intentionality. So basically, the court will first examine whether there is an intention to create family through the conventional forms of relationships, so marriage to start with. So as to any relationship that falls without the conventional pattern, the court will carry out a more functional-based analysis of intentionality, and basically the court will look at whether there is a real existence in practice of close personal ties. So the real existence of close personal ties will be tested by the court to establish whether family life, whether a family tie was present in the case in question. So of course, from a theoretical point of view, a similar approach seems ideal to extend the definition of the family beyond the traditional family model to include non-traditional family arrangements. However, exactly because the court seems to value the concreteness of the emotional and social ties existing among the family members. However, in practice, this outcome very much depends on the way the test is applied, and I would say, more importantly, depends on whether the court attaches the same value to the same factors when it considers whether a legal tie of fatherhood or a legal tie of motherhood can be established. The second reason why I think looking at the European Court of Human Rights jurisprudence is interesting, is relevant, is because the court has consistently recalled that the convention has to be interpreted as a living instrument. So basically it falls within our legitimate expectations that the family, the concepts of motherhood and fatherhood are adjusted to the existing social reality, so are made in compliance with current expectations, norms, and practices. So these interpretive techniques has, again, from a theoretical point of view, similarly to the first point that I mentioned, the potential of departing from a limited definition of family to extend the legal treatment that has so far been accorded to the traditional family model to non-traditional family arrangements. And there's also the potential to depart from the traditional division of labor, so the traditional gender roles, thus reshaping fatherhood according to current expectations and also in a way that facilitates the job of mothering. So for these two reasons, I think that the European Court of Human Rights can be seen as a strong potential activist actor in the struggle for gender equality, both within and outside the family. So the core question that I'm trying to address is whether the European Court of Human Rights challenges or merely reproduces the traditional ideology of the family that is intended as a formally celebrated union between a man and a woman, whose functions are distributed along gendered lines. To carry out this analysis, I will suggest three different constructions of fatherhood. The first one, that is the most straightforward one, is represented by the genetic father. The genetic father who is intended to be the man who offers the sperm that leads to conception. The second definition instead is the nurturing father, that is intended to be the individual who has parenting intentions and consistently acts as a parent towards the child. So intention and actual commitment, actual involvement are the key notions defining this construction of fatherhood. The third construction, the third definition that I'm proposing is the most confusing one, because unlike the first two definitions, they are somehow static in nature. The third one, the content of the third definition varies according to the case law domain that I'm looking at. Because basically, according to the conventional fatherhood definition, the conventional father is the individual who has those features, both physical and temperamental, and or plays a role which is conventionally tied to the father figure. So as I said, unlike the first two definitions, it's kind of more difficult to imagine like the image of the conventional father because it changes. So for instance, in the domain of artificial reproductive technologies, the conventional father is likely to coincide with the genetic father. because in this domain, the feature that is deemed the most relevant by culture is the biological time. So there is an overlap between the two definitions. In the domain of family work reconciliation, instead, the conventional father will be likely to be the breadwinner, because in this domain, the features that is conventionally tied to the father figure is the financial support to the family unit. Another example, the realm of same-sex couples is governed by the conventional norm of heterosexuality, and as a consequence by the different-sex parental model. So these will be the features that exemplify the conventional fatherhood when the court has to decide about same-sex parenting issues. So as you have already noticed by the examples that I've just given, the three definitions shouldn't be considered as mutually exclusive. Actually, very often they overlap. So, having provided this theoretical framework with the three definitions of fatherhood, now I will try to guide you through the main findings to date. So on the basis of the jurisprudential analysis that I've so far conducted, the overall picture seems to be that the court has rejected the genetic construction of fatherhood, and there is a continuous overlap of the other two constructions. So basically, the court doesn't adopt a unitary definition of fatherhood, but refers to the concept of nurture or to cultural norms, depending on the case law domain that is analyzing. So far, I've looked at three different case law domains. The first one is artificial reproductive technologies, the second one, post-separation, divorce, contact, and the third one is family work reconciliation. And I'm now finishing the fourth case law analysis that is about same-sex couples, but I haven't included it yet in my presentation, so it's still kind of work in progress. So starting with the artificial reproductive technologies cases, we can see that although the genetic construction of fatherhood is being increasingly deprived of its historical importance to the advantage of a nurturing construction of fatherhood, namely sperm donation is not sufficient to be recognized as a legal father, the full endorsement of a nurturing construction is prevented by the persistence of conventional norms. So I'll give you an example. For instance, in the case of XYZ versus the UK, there is quite an old case, it was decided in 1997, but just to give you an example of the reasoning employed by the court. This case concerned a transsexual that had a child with his male partner through artificial insemination. So they had been raising the child together. So at some point, this person, the transsexual, applied for his social tie with the child to be legally recognized. So according to UK law, this was not possible. And what is interesting is that, on the one hand, the social reality, so the social tie between the applicant and the child, proved decisive, because the court found that family life could be established between these two individuals. However, didn't prove decisive enough, because then the court said that there was no violation due to the fact that states enjoy a wide margin of appreciation in matters related to transsexuality. It seems to me that the margin of appreciation doctrine was used as a conclusory label to actually conceive the true basis for denying the recognition of parental rights, paternal rights, and responsibility to this man. And the true basis was actually made explicit by a concurring opinion. And the concurring opinion basically said that although the applicant had irrevocably changed some of his physical features, it was deemed culturally unacceptable to attribute paternal rights and responsibilities to a person who did not possess the basic requirements for being publicly recognized as a father. So basically, it is indispensable to be born biologically male to be recognized by the law as a father. Moving to the second case law domain that I've been looking at, the post-separation divorce contact. In this domain, it seems that the depiction of unmarried fathers as irresponsible, uninterested in their children, has been replaced by a more, I would say, positive perception, namely those of men who are actually interested in maintaining contacts, a relationship with their child, and actually sometimes they're even subject to discrimination, either by the law or in practical terms, they are prevented from maintaining contacts with their children due to hostile mothers or this kind of stories. So the construction of fatherhood emerging from this case law domain significantly departs from the marital presumption. And of course, this is positive. I mean, the court kind of somehow moves beyond the idea of marriage as the only institution that implies the necessity and also well-being for children due to contact with their father. So the court moves beyond this point, extending the privileges of legal fatherhood to unmarried fathers. However, this shift is not complete in the sense that although the court says that fathers can't be discriminated on the basis of their marital status, the court says that it's legitimate to distinguish between married and unmarried fathers in the sense that unmarried fathers shouldn't be given automatic rights as it happens within the marriage context. So unmarried fathers will be attributed paternal rights and responsibilities, in this case, the right to contact, only if they meet a test. So according to this test, biology represents only the starting point, and it has to be complemented by evidence of nurturing practices. I mean, not really nurturing in the literal sense of the word, because, for instance, the court considered to be a factor deserving consideration the fact that the father, for instance, instituted proceedings to be awarded contact. So the fact that the father actually tried very hard using legal means to maintain the contact with the child was considered by the court as an evidence of the intention and the actual commitment of the father to participate in the child's life. However, I think that to somehow underline the potential of a progressive contribution by the European Court of Human Rights in redefining the rights and responsibilities of fatherhood, I think it's necessary to, I would like to turn your attention to a recent decision. Not as recent as it used to be when I wrote this paper, because it was 1 year old. In the case of Konstantin Markin versus Russia, there is a case that was decided by the Grand Chamber in March 2012. So the legal issue at stake was whether the refusal to grant parental leave to a serviceman when this entitlement was made available to service women constituted a discrimination on the ground of sex. The applicant was a member of the Russian army, and he had 3 children. And after his divorce with his wife, he was left to raise these children on his own, and the children were very small, so he decided to apply for a 3-year parental leave to look after his children. And according to Russian law, this is not possible for men, it's just possible for women in the army. Actually, from a gender point of view, I think it's quite interesting to look at the justifications that were provided by the Russian constitutional courts when denying the award of this entitlement to the applicant, because the court said that The idea of reserving this possibility to service women is due to the special role that motherhood plays in childcare. So of course, the court was offered with a wonderful opportunity to kind of either contest, I would say either name, either support, either contest gender stereotyping. And I think the intervention of the court in this case has to be praised for the following reason. I mean, first of all, the court recognized that insofar as the role of taking care of children is concerned, men and women are similarly placed. And then it went on to say that references to tradition, general assumptions, and societal attitudes in a particular country cannot be used as sufficient justification for a difference in treatment. So gender stereotyping basically is not a valid, legitimate justification for discrimination. And the court also said that states are prevented from imposing traditions that derive from the man's primordial role and the woman's secondary role in the family. So apart from raising women's inferiority in the public sphere as a concern, the court threw light on the other side of the coin, namely the inferior status that is sometimes attributed to fatherhood in the domain of childcare compared to motherhood. So the court seems to have grasped the structural dimension of the discrimination at issue, and the open recognition of a two-sided arm of gender stereotyping constitutes, in my opinion, an essential premise for the development of a transformative equality project. So this recognition of the two-sided harm conveys the valuable idea that dealing exclusively with the female side of the issue, that in this case, in the context of family work reconciliation, means accommodating the needs of women in the workplace, so improving working conditions of women, does not eliminate the underlying causes of exclusion, but it merely addresses its manifestations. So it's necessary to intervene on both sides, and actually on both sides at the same time, because the sustainability of any change in the public domain of life, of course, depends very much on the occurrence of a corollary change in the private sphere of parenthood. So the court's departure from the conventional family model can be read as saying that primary commitment to paid work per se does not ensure the recognition of a legal tie of fatherhood anymore. Fathers are required in order to be awarded the right to parental leave, in this case, are required to show that they actually participate in the child's life. So evidence of nurturing practices is necessary for a legal tie of fatherhood to be established. So I've basically tried to summarize the main findings to date. So the following question, that would be the third why question, is why human rights? I mean, on the basis of the analysis that I've just briefly shared with you, the question is, are human rights the right tool for achieving changes in family practices? So as argued by Martha Feynman, the nature of the law is conservative. So basically, the law shouldn't be seen as a way of transforming society, but it can merely result, the employment of legal means can merely result in somehow formalizing, like affixing a legal seals to those practices and ideas that are already widely shared and accepted as appropriate. Also, feminist legal theories have since long criticized the employment of human rights tools as an ideal way, as the ideal means of changing family practices, and have criticized human rights as an individualistic ideology of personal autonomy, which is considered to be anti-family and community. So basically, my argument is the following, that although the law is conservative in nature, the advent of the human rights movement has significantly empowered the law and increased its activist potential for two reasons. I mean, the first reason concerns the way human rights provisions are normally formulated. So the core concept that individual rights can be limited by law for the purpose of protecting or respecting the rights of others. So for instance, Article 8 of the European Convention of Human Rights, we have the first part, the first paragraph that provides for the right to respect for private and family life, and the second paragraph that, in my view, imposes duties on the individual to the family, to the community, because it says that this right can be limited, the exercise of this right can be limited, can be restricted in order to protect the rights of others. So I see the possibility of restricting an individual right in order to protect the rights of others as a way of expressing communitarian values. So as a way, as a measure that shouldn't be considered as anti-family and anti-community. And taking into consideration, again, Article 8, I think that the way it's formulated, the two paragraphs, actually represents a successful attempt to strike a fair balance between, on the one hand, the individual rights, and the other hand, the duties to the family. This notion comes out of also from the court's decision in Markin versus Russia, as well as in the jurisprudence of the court about unmarried fathers, that demonstrates that moving beyond the surface of the family to the interests and needs of an individual, of a member of the family, of an individual, does not compromise, but on the other hand, it enhances the relational dimension of the family, thus contributing to the well-being of the other caretaker and the children. This is the first reason why I see human rights as an empowering tool. The second reason why I think human rights are a useful tool to change family practices is the following. So the second reason relates more to the way human rights have been interpreted and applied by international courts, by constitutional courts sometimes, and by human rights monitoring bodies. So in particular, I'm referring to the emergence of positive obligations on the state. So it's a necessary step in the process of ensuring human rights protection at the state level. So it follows that states are no longer required to abstain from any interference in the private domain of life, but actually they are demanded to actively intervene to create the circumstances on the basis of which an individual can fully exercise his rights. So apart from transcending the public-private divides, the coexistence of negative and positive obligations on the state has, in my view, successfully merged the two dimensions of human life, and thus acknowledging the fact that the two dimensions, as I previously said, are complementary, and therefore a change in one has to be corresponded by a simultaneous change in the other sphere, and has in this way also pushed the boundaries of the law beyond its historically conservative boundaries. So this development, apart from having occurred at the level of interpretation, can be noticed also in some of the human rights provisions, so in the way human rights provisions are actually formulated. So for instance, if we take into consideration Article 5A of the CEDAW, in my opinion, this provision constitutes a great example of the current understanding of human rights as a relational tool with a systemic rather than individualistic focus. So basically, according to Article 5, state parties are required to take all appropriate means to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes. So basically, I'm taking this provision as an example of the fact that the interpretation or the formulation of human rights provisions implying both negative and positive obligations by the state has also resulted in a call for a more responsive and responsible state, which of course is at the core of the vulnerability theory that Martha Feynman has developed. So now this way I'm kind of moving to the last why question. As I told you, it's not complete yet. That's precisely what I'm planning to work on soon. And the idea is that, first of all, my project conceives human rights theory and the vulnerability theory in alternative terms. So I'm trying to combine the two, and the starting point consists in incorporating the notion of the vulnerable subject to describe the human condition of men, so as trapped in their breadwinner role, with, as a result, very limited opportunities to engage in the realms of love and care. So that would be the starting point. And also the idea is to, drawing on the experience of fathers' rights groups, of the father rights movement in general, that hasn't been always very successful, so drawing on this experience, on the lesson learned by this movement, I'm trying to offer a feminist analysis of the current institution of the family that, rather than demonizing men, like sometimes happened with the fathers' rights movement, demonizing the female counterparts, rather than demonizing men, tries to include them as participants in the reconstructive project. Okay, I'm done, actually. As I told you, the last part was not really, it's not very developed yet. But basically, yeah, maybe I don't know whether I was clear at the end, but I think that I'm trying to see how human rights also, as a tool, can be used to address vulnerability. So, like, of course, the underlying idea is that human rights make the state more responsible. So in that way, increases the chances of the state providing resilience to the individual, that in this case is the father. So yeah, that's the idea.
We consider the vulnerability of the mother and the vulnerability of the child and the vulnerability of the larger society too?
Yeah, I mean, yeah, that's the, I would say that's the tricky part of family law in general. Like, you can't just focus on one individual, because of course, since the goal is the well-being of the family unit as a whole, then you need to make sure that practices concerning fatherhood are are framed in a way that the overall well-being is ensured. So of course, I'm planning to also look at the vulnerability of the children and the mother. And I think it kind of, as a domain, case law domain, that actually makes this exercise more visible than in others, I would take family work reconciliation. Because then, in that case, I see first of all, I see the structural dimension of discrimination, or in any case, the need for a structural, systemic analysis, very, very evident. And also, as a consequence, the idea of complementarity between the two spheres of life. So I think in that precise domain, it makes a lot of sense to kind of compare the vulnerability of the father with the vulnerability of the mother, and as a result also the consequential vulnerability of children due to the fact that there is no time for care and we have to keep up with the workplace requirements, stuff like that. So yeah, that's the idea, but I don't know, have you, oh no, yeah, I'll ask you later, yeah. Is better if you ask me questions then. Yeah.
Well, thank you so much for that. That was really interesting. I guess it's interesting to me to hear the precariousness of the father and hear about the precarity of fatherhood, because maybe I'm one of those feminists that are like so anti-men, but in the research that I do, it's always the sense that men's rights are actually very actualized, and that certainly with lesbian couples using sperm donors, for example, which is what my research really focuses on currently, is that I can't think of a case in which a man articulated some interest, like a donor, articulated interest in being, having some sort of fatherhood role, having some kind of a parental right that was denied to him, because in every moment of adjudication, the courts always determined that any man that was interested in being a father must be, therefore, a good father, because that like any desire for that kind of nurturance then allowed him to assert whatever contracts they'd written before their birth about his limited role as a donor, and in a sense that men's rights are actually really profound and really well articulated when it comes to this kind of zero-sum relationship of a diminishing motherhood and an expanding fatherhood. So there's been quite a lot of discussion in Canada, at least, around that. I'm concerned that giving too much focus to men's rights is a way of maybe endangering certainly a motherhood that doesn't involve a man and intentionally doesn't involve a man, and also single motherhood as well. It's quite precarious because any dad that wants to be a dad must be a really good dad.
Yeah, no, okay, I of course I take your point. The idea is to, I mean, first of all, just small comment on the artificial reproductive techniques case law domain, because of course in that precise domain, fathers have a limited opportunity, I would say, limited opportunities to kind of show their commitment. I mean, in the sense that they're not really, it's not like in the post-separation scenarios where actually the father has lived for some time with the child, so you can actually test whether his intentions then are followed by actions or not. In the reproductive domain, of course, the father is not given this chance, so the only element that you can take into consideration is the preconception intention. So I agree with you, there is a very, very small space for nurturing, arguing for the endorsement of a nurturing construction of fatherhood in these cases. However, there have been cases where the father, like the donor, of course, is not an unknown donor, maybe it's a friend of the lesbian couple, and he wants to maintain contact with the child. I think we should, like, when we talk about paternal rights, parental rights and responsibilities, then of course you also need to look at the specific rights, the specific parts of the paternal rights and responsibility group, in the sense that in this case, I don't really see why a father, like a biological father, shouldn't be, for instance, should be forbidden contact with the child. I mean, because it happens sometimes. I mean, I read some cases that the lesbian couple at some point, they decide, okay, no, you don't see the child anymore. That's our child, maybe for a fear of, it's true, like creating also confusion in the child's life in terms of how many parents do I have. But I think that's, again, somehow reproducing one of the conventional norms that is like, the child has two parents, that's it. It can't have third parental figures. Yeah, so that's the, and when you said about the zero-sum framework, I mean, that's what I'm trying to avoid. That's what I'm trying to argue for. I'm trying to find a way of combining, on the one hand, the more balanced fathers' rights groups arguments and the feminist arguments. So I'm trying to find a way of achieving equality as a win-win situation rather than as a win-lose. But apparently it's sort of also difficult to convince both parties that it's feasible. So yeah, that's the struggle.
It's just the way that articulation excludes what I asked you about, which was the vulnerability, because it always becomes a question between mother and father. And you know, it's this binary, it's the, you know, that becomes the issue, and their equality rather than other things. Like I would look at the lesbian couple in terms of the vulnerability of their relationship too. So even beyond the focus on individual to truly relational things, which I think a rights paradigm doesn't really allow you to do. I mean, you can articulate it that way, but it doesn't play out that way in terms of making decisions, because rights focuses us on a very limited set of concerns or circumstances. And it also doesn't tell us how to resolve things when the mother's rights conflicts with the father's rights, for example. So a rights paradigm is in many ways an impoverished way of looking at these very complex situations that excludes a whole lot. So that, I mean, I'm willing to be convinced otherwise, but you know, but you have to do that.
No, I understand that. Of course, like starting again from the way Article 8, for instance, is formulated, of course, you have everyone has the right to blah, blah, blah. So, of course, you have a series of individuals who can claim the same rights, you know. But that's precisely when the interpretation comes in, like as a way of solving things, as a way of adjusting legal concept to social reality. And in this way, I would say, like, for instance, the court has very often used the balancing approach. Of course, I agree with the fact that the outcomes of a balancing approach are very uncertain. You don't really know what you can expect. But at the same time, I see it as a positive, I see it as a good way of concentrating on the factual circumstances defining that specific case, rather than taking a categorical position. So, yeah.
Staying a little bit in the topic of reproduction, in 2011, Grand Chamber decided in the case SH versus Austria that they not allowed for sperm and ovum donation in IVF procedures, and that was very much grounded in this community and social reality and respect for tradition. So Austria received a wide margin of appreciation that granted the country to decide about sensitive topic as this within their own structure and societal preferences. So I was wondering if since then, if in the other cases there is a change, some kind of change that in one or the other direction, that the court don't want to grant so much or won't grant a wide margin of appreciation in those kind of situations, and family situations when they're allow the country, regardless of the society, what they think about it, because I don't think they didn't really refer to any kind of statistics about it. So,
no, actually, that's one of the big obstacles that you encounter when you analyze the jurisprudence of the European Court of Human Rights. So like very often, of course, when the court decides that there was no violation because a wide margin of appreciation had to be granted to the state, in my analysis, of course, I always try to go beyond that to kind of see what was the actual reason behind the decision. Because of course, if you stop at that point, then there is no possibility of doing any sort of analysis. But unfortunately, I have to say that, yeah, I have two examples. I mean, one that is related to ours, and it was a case decided in 2006, if I remember well, again against the UK, Dixon's versus the UK. And there was a case of a couple, both of them were in prison, and they wanted to have a child via artificial insemination, and it was going to be the only realistic hope for this couple to have a child. So they were denied this possibility according to UK law. So the Chamber basically said that there was no violation. Again, I mean, I'm always trying to kind of interpret the court's reasoning, because of course the court is never very explicit, so that's my own interpretation. That somehow, fortunately, is supported by concurring opinions, so it's good that there is some sort of backup. So, for instance, in this case, the chamber said that there was no violation because it's not good for a child to be born by a person, a former inmate, or because at some point it would have been released, but it's not optimal for the child to be born by a person who has committed one of the most serious crimes, because I think it was homicides. And also, there was, besides these sort of implicit observation, there was also a reference, again implicit, to the preference to be accorded to a dual parental model. Because the mother was going to, although she was also in prison, she was going to be released like soon, like a couple of years. Instead, the father was going to stay in prison for the 10, 15 years. But the court, the Grand Chamber then overruled the Chamber's decision. And so basically they said that public opinion shouldn't be taken into consideration to justify decisions of this kind. So the fact that, according to public opinion, it's not great to be raised by someone who has committed a very serious crime shouldn't be taken into consideration. And also, the court said that in any case, at some point, the father was going to be released. So, you know, as a temporary measure, the child could have been taken care of by the mom. Of course, I mean, by looking at the decision from my point of view, like from the father's point of view, this decision is not, I don't fully support this decision, because somehow by saying that, okay, it doesn't matter, the mother can look after the child for like 10 years, and then at some point the father will kind of join her, of course, again, you kind of reproduce like the stereotypical belief that a father's participation is not necessary, and so the contact with the father is not necessary for the well-being of the child, and the mother can take the whole burden herself. But a negative, like on the other side, replying to your question whether the court keeps referring to national perceptions as what is appropriate or not. I mean, I think it's quite alarming and quite indicative the fact that in the context of same-sex couples, the court managed to establish that a same-sex relationship amounts to family life in 2010. So it took the courts 3 decades to actually kind of move beyond the sphere of private life, because before 2010, same-sex couples' rights issues were considered as falling only within the private life domain, not the family life. So I guess, yeah, I mean, that's a problem. And also, when you were talking about statistics, and that's unfortunately something that the court doesn't do unless there are third parties intervening, so providing further evidence. But I have to say, in Europe, it's not very common. Like here in the US, you have amicus brief, and I mean, that would be very useful for the court to kind of increase their knowledge, especially from a sociological point of view, before deciding, but that's not the case. Actually, very often, I mean, I have an example in mind. In the Konstantin Markin versus Russia case, the court said, because in that case, the court overturned a previous decision, Petrovic versus Austria. It was the same issue, parental leave to a man. In the previous case, the court said it was in the 1990s, so the court said that there was like no shared European consensus, so wide margin of appreciation had to be granted. In Marking versus Russia, the court said actually there has been an evolution according to which societal attitudes towards men as caretakers has changed. Or for instance, they say something related to the belief that there is a special bond between the mother and the child. So the court contested this belief as kind of scientifically unfounded, but then the court never provides evidence. You know, they don't refer, or maybe they say, studies have proved that, that there is no reference to any study. So that's of course a problem. So I myself kind of believe in judicial interpretation as a way of like transforming society more than kind of legislative changes. But I also think that judicial action should be always supported, especially in this range of cases, should be always supported by non-legal evidence. So that's of course one of the issues that I will have to face later on when I will look at the legitimacy of the court in defining who is a father, who is a mother, what is a family. So of course, who is the court? I mean, on which basis can we say that the court is the right body to decide, to answer to these questions, especially in light of the way the court operates? As I said, it's not really looking at outside law types of evidence. Yeah.
So you've given examples of cases where courts either reinforce the traditional stereotypes about family and also examples where they challenge those. So what would be your conclusion? Do you feel like the European Court on Human Rights is actually challenging?
Oh, the conclusion would be, I mean, I still have to finish my analysis about same-sex couples, and I still have to look at the family reunification related jurisprudence. But on the basis of the analysis that I've so far carried out, I can say that, yeah, of course, I mean, the most obvious answer is between the two, like, in the sense it challenges some of the aspects of the traditional ideology, but then not all of them. So the aspect that has been challenged is the genetic link. So it's necessary to create a legal tie of fatherhood. That specific aspect of the traditional ideology has been overcome. But then unfortunately, when it comes to nurture or conventional rules, I can see that the court tends to tends to prioritize conventional rules over nurture. So I can see, so far I can see it's also a sort of hierarchy, you know. So you have genetic at the bottom, and then nurturing, construction, and at the top you have the conventional rules. But yeah. So I have to say, of course, I'm being very critical of the jurisprudence. I mean, that's my job now as a researcher, of course. But what I'm trying to say is that basically human rights might be the right tool if they're used in a specific way that unfortunately is not being the way the court has used them so far. Yeah.
Thank you very much.
Thank you.